Kane, you're going to need to take off your hat. You're in court.
You're in court.
Department of Family and Protective Services versus Kane. This is a court-ordered services case. So ask that for announcements, and I want to know who you are and what your relationship is to this case. So we'll start with Mr. McKeska.
Well, thank you, Judge Drake McKeska, attorney for the department. Mr. Santiago Chavez.
Irving Santiago, investigator.
Jimmy Dresden Mitchell, investigation supervisor.
Jennifer Harris, attorney for the mother, Miss Ariana Kane. Miss Kane, can you say your name, please?
I am Ariana Kane. I am the mother.
Okay, Kurt Rutkin, appointed to represent Father Jesse Kane. I believe he's on as well.
All right, Mr. Kane, would you state your name, please?
My name is Jesse Kane. I am the father.
All right, thank you.
And Lucinda Mance, I'm the attorney ad litem for the children, and I am ready. Thank you, Judge.
All right, thank you. I'm going to ask you to go ahead and tell me how you all wish to proceed today, Mr. McKeska. I don't know if you all have had a chance to confer about potential services. Go ahead, Mr. McKeska.
Judge, I think Ms. Harris and I did speak a few minutes ago. But I think it might be beneficial if all the attorneys could be placed in a breakout room so we could just have a quick discussion, see if we're all on the same page.
Okay. All right. Can you do that, Ms. Greenlee? So we'll have just the attorneys are going to go to a breakout room. That means you won't be able to see them on the screen, but I'd ask the rest of you to just stay where you are, and we'll let them have a chance to confer and see if we can work something out. It's always best to me in these cases if we can figure out something that all parties agree would be beneficial to the family. So Ms. Greenlee will go ahead and get you all in a breakout room.
Judge Morris.
Yes.
I may have to step away for a moment. My son, Christopher, he gets on the bus at 9:45, and I'll have to go put him on the bus if I may have to step away.
All right. As long as your attorney is authorized to appear for you in court.
Yes, ma'am.
You do whatever you need to do.
Yes, ma'am.
All right. Thank you. All right. So we are, looks like for the record that all the attorneys are back appearing at this hearing. So do you wish to make an announcement about how you wish to proceed, Mr. McKeska?
Yes, Judge. After being able to confer, I think we're all in agreement to ask the court for a reset for maybe 2 weeks or so. That way we can hold a family team meeting or family group conference. There's a lot of information that's been provided today indicating that services are ongoing and those sorts of things. So we'd just like the opportunity to be able to all sit down together and vet that information out before proceeding with the MTP.
All right, we can do that. I will ask Ms. Greenlee to look at some dates, but while she's looking, I want to advise you, because it looks like Ms. Kane, you're back on the call. Ms. Kane thought she was going to have to leave for a minute, but when I give you all a new date, it's important that you both, come back to court. And what I would suggest to you is that I've read the report. I know there's some differences of opinions about what the situation is, but it sounds to me like there's no question that your family could benefit from some additional services, no matter what the problem is. Some counseling, family counseling. I'm not here to tell you exactly what those services are, but I want you all to go to a family group conference. The purpose of those is that everybody can sit down and talk about what they feel like they need. If there's something you think you need, whether it's individual counseling, marital counseling, maybe you need some sort of, anger management class, or whatever it is, you need to have input into what that might be. And both parents have attorneys that can represent them at that meeting and advocate for what their needs are. There's also an attorney for your children, and Ms. Mance will be advocating for what she thinks they need. It may be that it sounds like maybe Christopher does have a psychiatrist. It may be that he needs additional therapy or something. So I just want to admonish you all about that. All right, what I'm going to do is, for the record, I'm ordering that you all conduct a family group conference prior to March 8th at 9:30. And I'm ordering that you parents both participate in that. Do you both understand that? You can nod or say yes if you do, or if you have a question, let me know. You both understand that?
Yes, ma'am.
Mr. Kane, I see you nodding. So both parents are indicating they understand this, and we'll be back then on March 8th. Are there any orders that need to be made prior to that date other than ordering the family group conference?
Judge, I am sorry. I had my dates messed up.
Okay.
The 8th is our Bandera docket. Can we come back the 15th at 9:30?
Let me look real quick.
That's our dates are pretty full. We have trials and
I can do that. Will that work for everybody else? The March 15th at 9:30?
Yes.
Yes,
see,
Judge.
he nods. I don't see anybody saying they're not available. So that gives you a little more time to get together and discuss what specific things you need to participate in.
And that'll be by Zoom, right?
Yes. Unless I hear an objection from someone, then we will be appearing by Zoom. I'm a visiting judge, and so I'm not traveling regularly with the regular docket, and due to lack of courtroom space and other concerns. So if everyone's in agreement, we'll be appearing by Zoom on that day. Are there any other questions from anybody?
No, Your Honor.
All right, then good luck to you all. And I would suggest again to the parents that you all think about what you think might really be helpful to your family. Okay, I notice the parents aren't here. Are you all expecting them?
No, Your Honor.
Your Honor, I'm expecting Mr. Hawkins, but I'm going to call his unit to make sure they received the order.
Okay. Because I know we were hoping that expecting that the parents might sign voluntary relinquishments.
And Your Honor, there's an update on my client. I don't know if you want it now or if you want me to wait and see if he's going to log in.
Well, let me call the case. Is he the only one that we're missing so far? Okay, yeah. I'm going to go ahead and call the case, and if he logs in, we'll try to get him in, and then you can give the update when we have announcements. Okay, this is actually a recall of the case that was heard on, let's see, I don't know which date. I don't know the date of that offhand.
January 19th, Judge.
January 19th. Okay. This case was originally called for hearing on January the 19th. And for the record, the trial was commenced. We started with testimony, then we had a recess and came back today, February 16th. So why don't you start us off, Mr. McKeska?
Thank you, Judge. Drake McKeska, attorney for the department. Ms. Sartucci?
Alejandra Sartucci, permanency specialist with Belong.
Lucinda Mance for the children. I'm ready. Thank you, Judge.
Yeah.
Irene Acosta for the father, Isaac Hawkins.
Right, Ms. Savage, you want to go next?
Kathleen Savage for the respondent mother, Sydney Cavness. We're ready, Your Honor.
All right.
Goldie Rabson, Hill Country Casa, guardian ad litem for the children.
All right. So, as I said, this is a case that was recessed. Did I miss somebody? Okay. And so let me get the department's position of how you all wish to proceed today, Mr. McKeska.
Yes, Judge. So we have received Ms. Cavness's relinquishment. So we would like to go ahead and prove that up today. Ms. Acosta and I have spoken regarding Mr. Hawkins's relinquishment. It's my understanding that he executed it, that Ms. Acosta actually witnessed him execute it. But the facility he's in, rather than mailing it to her as requested, they destroyed it. And so we're kind of in a weird position today, knowing that he did execute it. He did follow through with the MSA. However, we don't have the actual document.
Okay. What do you want to add to that, Ms. Acosta?
Yeah, I did see him sign it. I saw the two witnesses sign it. And when I spoke with the facility and asked them why I never received it back, they instructed me that they shredded it, and that I wasn't going to be receiving it back. When I had initially spoken to them, they had told me that it was perfectly fine for me to email it to the law library and they would print it out and facilitate the signing. And they facilitated getting extra inmates to witness his signature on the document in front of me and in front of a guard. But in between that happening and now, I spoke with them yesterday inquiring as to why I never received it in the mail. And they said, well, because it was printed out at the jail, they shredded it because apparently someone told them that they couldn't mail it back to me. And I'm not sure what, anyway, I'm not going to speak to their policies or anything like that, but Mr. Hawkins did sign it. If he doesn't log in today, I have no way of coming to any other kind of agreement with the department with regard to vacating the MSA or agreeing to other grounds on Mr. Hawkins. His understanding was that the relinquishment was going to be accepted. And so if I can have just a moment to call the facility and see if they're going to get him on the hearing right now, I'll do that.
Let me pause for a minute because I don't know that helps us, you know.
I know.
And so I have a couple of thoughts about how we could proceed. One, we could proceed to prove up the mother's relinquishment and enter a, I guess you'd call it a partial final order, or
interlocutory order.
Interlocutory. I couldn't think of that word. Interlocutory order, and then my question is, where physically is he located?
He's in the memorial unit. So
where?
Let me look it up, Judge. It's in Brazoria County, so
I'm wondering, because that's Houston area, that's pretty, populous area. Is there anyone we could get from that area to physically go to the jail there, take a copy, of where the department could email them a copy of it and get someone who's in that area actually physically go to the jail and get him to sign it again? Because I don't think that I can terminate his rights based on a relinquishment if I don't have it. And the other thing is we could go forward on, other grounds. It wouldn't be by agreement.
Ms. Acosta and I did speak about that, Judge, and she would need to talk to her client, but we did talk about possibly stipulating to another ground, either N or O, and basically modifying our MSA, and then including in the order specific findings. The court found that the terms are original agreement, that he executed it, but there were these other circumstances, and so we proceeded on a different order, something along those lines. But she would just need to be able to speak to her client about that and whether or not we could modify that agreement.
Your Honor, I don't think we've commenced trial, if I'm correct. So we could commence, prove up Ms. Cavanagh's recess, and then
we did commence the trial. We did commence
that's correct.
On January the 19th, but we could recess again. There's nothing that says I don't think that you can recess a second time. Is there? So,
no, Judge, the only requirement is that the court is supposed to finalize the trial within 90 days of commencement. If the court's unable to finalize it within that 90-day period, there has to be specific findings extending that 90-day period. But We, as far as the dismissal deadline is concerned, we've commenced, and so there aren't any sort of dismissal deadline issues.
So my thought is what I would like to do is proceed as to the mother today, because that's an important piece, and we could get that done, and we could, dismiss Miss Savage, and the other thing is the father's rights have already been. He doesn't have rights to except one child, so that would leave one child completely taken care of, and then we would just so an interlocutory order could be entered. Just as to the other child. But why don't we take just a few minutes that you can contact your client, Ms. Acosta, and I don't want to take too long, and we will come back and then recess until another date, and that'll give you some time to either, talk to him or see how we want to proceed. Because in my opinion, we still have an MSA as to between the mother and the other parties. And so to me, the other option would be to proceed with termination against the father on other grounds, if we can't get this accomplished. So.
All right. And Judge, if for some reason the department wasn't able to get someone to go out there, if we were to recess, I can drive down there.
Okay.
To get it in person.
Okay. I mean, it just seems like that. I won't speak to the policies at the prison either, but obviously that's not really going to work. So I think if someone physically takes a relinquishment there and physically has him sign, and if you can do that, that's, I think it's worth it to get it taken care of.
All right.
All right, so we'll take about let's see, what time is it? Let's take about a 5 to 10 minute recess. And if you can't get hold of him or something, then come back and let us know, Ms. Acosta, okay?
I will, Judge. Thank you.
We'll just take a break. Everybody else hang around. You can put yourselves on mute or whatever, and we'll come back.
Your Honor. What they're telling me is they didn't get the order in time this morning, and so they're not able to make him available. I sent them the new one with the new Zoom link on it, and they're not going to have him available today.
Okay. All right. So my suggestion then is that we, as I said, just go forward with proceeding as to the mother, enter an interlocutory order today, and then recess as to the continuation of the father's rights to one child. Is that?
I'm fine with that, Your Honor. And again, if the department can't facilitate him having the affidavit signed, I'll go down there and I'll follow up with Drake within the next week to make sure he's going to be going.
He does have a courtesy worker in Brazoria County, so we'll see if we can get the courtesy worker to go out.
All right, thank you.
If just make sure that person knows exactly what they need to have, so that they leave the jail with exactly what they need, and because that I'm assuming that courtesy worker is gonna be a social worker, not a lawyer, and so I just want to make sure that they know what they need to do, and maybe that's something, Ms. Acosta, you could coordinate with them as well. So
yes, Judge.
All right, so we've already had announcements. We're back on the record. Are we back on the record, Ms. Greenwald? All right, and so I guess I'll just let you go ahead and proceed from here, Mr. McKeska.
Thank you, Judge. I'd like to I guess continue Mr. Tucci's testimony.
All right, Ms. Tucci, and just for the record, again, this case was called on January the 19th. The department started by calling Ms. Tucci, and she presented testimony on that date. I believe she discussed the reasons for removal of the children, and we had to recess before we were completed with that. And so you may go ahead and take her up where she left off, Mr. McKeska.
Thank you, Judge. And I believe she also testified as to the terms of the immediate settlement agreement that we had reached.
That's correct. That is correct. And the jury demand and sign relinquishments. Okay.
So, Judge, I'm going to enable the share screen for everybody to be able to see. Mr. Tucci, can you see my screen?
Yes, I can.
Okay. And do you see a document that's been pre-marked as petitioner's exhibit number 1?
Yes.
Okay. And this is a copy, a file stamp copy of the immediate settlement agreement that we previously reached in this case, correct?
That's correct.
Okay. And you testified to this previously regarding the terms of the agreement. But basically, the parents agreed to submit relinquishments and the department agreed to accept them and terminate based solely on those grounds, correct?
Yes.
And there's also a waiver of a jury demand in this case.
Yes, that's correct.
Okay. And then also the department will continue to make best efforts to pursue adoption by the maternal grandparents where the kids are currently placed.
Yes.
Okay. And that Ms. Cavness will have a in-person goodbye visit with the children, correct?
Yes.
Okay. Judge, I would like to introduce petitioner's exhibit number 1 into evidence.
All right. Any objections?
No objection.
No, Your Honor.
No, Your Honor.
With no objections, and I will state for the record that petitioner's exhibit 1 appears on the screen so that all parties can see it, and I can see it as well. So court will find that petitioner's exhibit 1 is admitted.
Thank you, Judge. Mr. Tucci, I'm going to scroll down to what's been pre-marked as petitioner's exhibit number 2. And can you identify that document for me, please?
This is the affidavit of voluntary relinquishments of the parental rights.
Okay, and for which parent?
For Sydney Cavness.
Okay. And at the time Ms. Cavness executed this voluntary relinquishment, she was represented by an attorney.
Yes.
And did she have the opportunity to review this relinquishment with her attorney?
Yes.
Do you believe that Ms. Cavness was able to have all of her questions answered regarding this relinquishment?
Yes, I do.
Do you believe that Ms. Cavness understood the significance of signing this relinquishment?
Yes, I do.
Okay. Did Ms. Cavness sign this relinquishment? Or sorry, excuse me. Did the department threaten Ms. Cavness in any way to get her to sign this relinquishment?
No, we did not.
Did the department promise Ms. Cavness anything in exchange for her relinquishment?
No.
Okay. I'm going to scroll down to the signature page. And Ms. Cavness signed this relinquishment, correct?
Yes.
Okay. And Ms. Cavness is currently incarcerated with the Texas Department of Criminal Justice?
Yes.
Okay. And so she included her inmate identifying number and where she's presently incarcerated, correct?
Yes.
Okay. Do you believe that she signed this relinquishment freely and voluntarily?
I do.
And that she did so believing is in the best interest of her children?
Yes.
Judge, I would like to introduce petitioners 2.
Any objection?
No, Your
objection.
No, Your Honor.
All right. Petitioners 2 is admitted.
Thank you, Judge. Ms. Zotucci, is the department asking for the court to terminate Ms. Cavness's rights based solely off of that relinquishment?
Yes.
And do you believe that termination of the parent-child relationship between Ms. Cavness and the 2 children the subject of this case is in the children's best interest?
Yes, I do.
Okay, and can you just briefly tell the court where the children are currently placed?
The children are currently placed with the maternal grandmother, Chandra Rowan.
Okay, and how are they doing in that placement?
They're doing well. They actually just got officially licensed on January 31st.
Okay, and the permanency goal for the children is adoption by the maternal grandparents?
Yes.
Okay, have you had the opportunity to observe the relationship between the children and the grandparents?
Yes, they're very bonded.
Okay, and can you just describe for us why you believe they're bonded with each other?
Kennedy is constantly following around Miss Rowan. Like she helps her do the laundry, she helps her go up the stairs. She's very attached. It's hard for Miss Rowan to really do anything without Kennedy following behind her. And Cameron is super, super attached to Mr. Rowan. Every time I go there, he's with him. And he described him as his little guy. They're very close.
Okay. And do you foresee any barriers to being able to achieve adoption by the maternal grandparents at this point?
No, I don't.
Okay. Judge, for the purposes of proving up Miss Cavness's relinquishment and some best interest testimony, I pass Mr. Tucci at this point.
All right, so I'll go to Miss Savage first.
No questions, Your Honor.
Miss Acosta, do you have any questions for Miss Savage? I mean, for Miss Zertucci?
No, Your Honor, I don't. Thank you.
All right, Miss Mance?
No, Your Honor.
All right, other witnesses?
Not with regard to Miss Cavness, Judge.
All right. Other witnesses that you wish to call, or how do you wish to proceed at this point?
Judge, I mean, I believe we can rest and close with regard to Miss Cavness, and then just ask the court to recess the trial to a later date with regard to Mr. Hawkins, so we can make additional efforts to facilitate his relinquishment.
Okay. And before I close on this case or make a ruling on this case, I would like to hear a report from Ms. Mance and from Ms. Rabson regarding the best interest, whether they believe this is in the best interest of the children. Ms. Mance, I'll start with you.
Yes, Judge. I have visited the children several times. I was substituted in. I visited the children at the home of the maternal great-grandparents, and then in the last month at the home of the maternal grandparents. They are very bonded to the family. They're doing well, and I think it is definitely in the children's best interest that mother's parental rights be terminated, and that the department move towards, upon termination of dad's parental rights, move towards adoption by the maternal grandmother and her husband.
All right. Thank you, Ms. Mance. Ms. Rabson?
Thank you, Your Honor. Yes, the maternal grandparents have been working really hard to take good care of these children, to bond with the children. I know that Mr. Rowan is working really hard to bond with Kennedy because Kennedy is so attached to Mrs. Rowan. And so they've been doing a lot of work to try and get her more and more comfortable with him so that Mrs. Rowan can have a little bit of a break sometimes. But they're doing really well. They're staying in close contact with the great-grandparents. CASA has no concerns.
Okay.
And we believe this is in the children's best interest.
All right. Thank you, Ms. Rabson. All right. Then the court, after hearing the testimony and reviewing the exhibits in this case, court will make the following findings based on the reasons for removal and the ongoing issues of both drug use and domestic violence in this case. The court finds that given the current placement of the children, the court finds it is in the best interest of the children to continue that placement. The court will adopt and approve the mediated settlement agreement today as to the mother only, Ms. Cavness. The court will accept her affidavit of relinquishment and again find that it's in the best interest of the children to terminate the parental rights of the mother, Sydney Cavness. Therefore, the court will enter an interlocutory order of termination as to the mother based on the 161.001K ground. I don't remember all the other letters, but y'all can come up with that. I know it's K. The court will also take judicial notice of the fact that the father, Mr. Hawkins, currently has parental rights as to the younger child. So the older child would that should be a final order as to Kennedy. I don't know if that's making sense, but we enter a final order. I would think it might be more legally correct to enter a final order as to Kennedy, and both parents' rights have been terminated as to Kennedy, and then an interlocutory order as to Cameron. We will recess this case to, let me just see what our next date is. I know March 15th at 10 o'clock. I will take note of the fact that Ms. Acosta and Mr. McKeska will coordinate to recreate a situation where Mr. Hawkins can execute an affidavit of voluntary relinquishment of parental rights. If for some reason that's not feasible, then the court will be ready on that date on March 15th to proceed as to other grounds or not go forward with Mr. Hawkins. I mean, we need to finalize this so that the children's situation can be permanent. So I will dismiss Ms. Savage from her responsibility in this case. Once that order is signed, she'll need to sign the final order when that is circulated. Ms. Acosta and Ms. Mance will continue on the case, as well as CASA. So am I leaving anything out? Court will just find that we did not address anything further regarding Mr. Hawkins on today's date, other than the attempts to try to facilitate this affidavit of relinquishment. Anything else?
No, Your Honor.
Okay. We'll get this taken care of one way or the other, I guess. So, all right. If nothing further, then all parties may be excused, and we'll see. And is that the 15th okay with you, Ms. Greenwald? Either you or someone else will cover?
Yes, ma'am.
All right. Thank you. All right. Then if nothing further, you all may be excused.
Thank you, Judge.
Thank you.
Thank you, Judge.
You.